Welcome back to the deep dive. Today we are undertaking quite an expedition, really. We're diving into maybe the deepest philosophical question behind all politics and society.
Which is,
What is justice? And maybe more practically, if we were starting completely from scratch, how should we, build a city to actually reflect true justice?
it's the towering question, absolutely. And for this deep dive, we're using your sources to explore that whole pursuit, starting really with Plato, in a massive thought experiment, The Republic.
Right.
And we're tracing that intellectual line, from his search for this ideal order right through to the, let's say, hard-won, very pragmatic legal systems of Rome.
And examining that constant tension between the ideal state and, well, the self-interested individual.
Precisely.
No, when most people think of Plato's Republic, they immediately jump to the really radical step.
Like the philosopher-kings.
Exactly. Philosopher-kings, getting rid of private property and family, at least for the rulers. And that very strict three-class structure, it just sounds so purely theoretical, like an ivory tower invention, totally disconnected from ancient Greece.
Well, that's the interesting part, isn't it? That feeling of disconnection is something our source material actually helps us correct. We found this really critical reference.
Okay.
It says Plato's really radical idea, this concept of communism, wasn't just some isolated philosophical leap he made on his own.
It wasn't.
No. It was, and I'm quoting here, suggested by the current communist theories of the day.
Wow, okay. That's crucial.
It really is. It means Plato wasn't just, dreaming this up in isolation. He was actively responding to the crisis he saw unfolding around him.
So the real world problems.
The real-world problems. Things like the severe economic and social inconsistencies, the inequalities that were plaguing Greek democracies. Think Athens, for example.
Where do you have political equality, supposedly?
Yeah. Supposedly. But then the rich held these vastly superior economic and social advantages. And that tension, that clash, it drove real, actual speculation at the time about maybe leveling the classes somehow.
So Plato's perfect city, the Callipolis,
Yeah.
which was all about harmony, right? Justice, meaning everyone does the job they're best suited for. That was actually born from the very real economic problems and disagreements he saw.
Yes, exactly. It was his theoretical solution to a very practical, very messy problem he observed.
And he built this ideal state as an analogy for the just soul.
That's the core of it. Justice in the state, for Plato, was this kind of harmony.
Yeah.
You have the rational part, that's the philosopher-kings ruling. They're supported by the spirited part, the guardians, the military. And the whole thing is maintained by the appetitive part, the producers, the workers.
Okay.
But the big question, really, for the rest of our deep dive is this. How did the actual historical states, the messy, real-world attempts at governing, how did they deal with it when the individual parts, the people, refused to stay in harmony, when self-interest kicked in?
That sets up our mission perfectly then. We need to unpack the struggles of those historical attempts. We'll look at the contrasting models, Sparta and Athens specifically,
Right.
and then see how later thinkers, legal experts, people like Cicero, the Roman jurist,
Yeah.
how they tried to find a more stable, rational, maybe universally applicable basis for law, something that moved beyond just relying on one person's virtue or, whatever the political consensus happened to be that week.
It's ultimately a comparison, isn't it?
Yeah.
The philosophical quest for some kind of eternal justice versus the, let's face it, pragmatic political reality of building a state that actually functions and manages human nature.
Okay, let's unpack this. Starting with those contrasting Greek models, Sparta versus Athens, restriction versus revolution, almost. So when we look at the ancient Greek world, Sparta and Athens really gave us these two fundamentally opposing blueprints for how to organize politically.
They can be much more different.
Athens represents that dynamic, often chaotic, democratic freedom. Sparta, on the other hand, represents, well, rigid, stable militarism. How on earth did Sparta manage to achieve that famous, almost legendary stability?
Well, fundamentally, by engineering a constitution that was specifically designed to prevent rapid change, to stop popular uprisings before they could even start.
A mixed constitution, you said.
Exactly. It was intentionally constructed with bits of monarchy. They had two kings, remember, oligarchy, and democracy. But crucially, it was always weighted heavily towards conservatism. Stability was the goal.
And the core of that stability was this council, the Gerousia.
The Gerousia, yes. The Council of Elders. That was the heart of the Spartan system.
Okay, tell us more about the Gerousia. How was it actually structured? What power did it hold?
Right. So it consisted of 30 members. That included the two kings. But the key eligibility requirement was age. You had to be over 60. And you were chosen for life.
For life, wow.
Yes. Think about the institutional memory that builds up and the resistance to, fleeting popular opinions. They were effectively the chief judges for serious criminal cases, the capital ones.
Right.
And they provided this incredible stability that counterbalanced the power of the two kings.
And getting chosen was a big deal.
Huge. Membership was seen as the highest prize for virtue, which, in practice, meant that the established noble families pretty much dominated this body.
Okay, so on the surface, that sounds very oligarchical. A small council, mostly nobles, elected for life, holding ultimate judicial power. Where did the supposed democratic element come into it?
Well, the democratic element was, shall we say, more theoretical than practical and deeply restricted. The actual election process for the Gerousia happened in the Appella, the Assembly of Citizens, yes, open to all Spartan men over 30. And the people in the Appella, they technically elected the Gerousia members. They voted on war and peace. They decided disputed successions to the throne. There was even an old statute that proclaimed, "To the people shall belong the decision and the power." It's democratic, right? On
Right,
paper.
there's always a but, isn't there? The devil's in the details, usually the selection pool.
Absolutely. And here's the critical restriction that ensured the oligarchy stayed firmly in control. Those 30 counselors, even though they were elected by acclamation, by shouting in the assembly,
Yes.
they could only be chosen from the established noble families. That one rule. That single mechanism guaranteed that real democratic influence was always kept in check. It cemented the political importance of birth, a tradition, over, say, popular merit or opinion.
What if the assembly, despite this, did happen to get a bit too enthusiastic? Too revolutionary, maybe? Or just too populist for the establishment's liking?
Well, that brings us to the ultimate safety valve, the final check on the popular will. It's called the Crooked Decree Clause.
The Crooked Decree Clause? That sounds amazing. What on earth is that?
It's a fascinating bit of constitutional history. The very same statute that theoretically gave the people the power to decide things also gave the executive authorities. So, the elders in the Gerousia and the other magistrates, the ephors the power, and listen to this phrasing, to be seceders if the people make a crooked decree.
Seceders, meaning they could just walk out, ignore the vote.
Essentially, yes. If the popular will, as expressed by the assembly, was deemed faulty or destabilizing or, a dangerous departure from the conservative traditional way of doing things,
Like what sort of thing might be crooked?
well, perhaps a decree advocating for a radical redistribution of land, maybe, or a sudden ill-advised war against a powerful neighbor that the establishment thought was foolish. If they judged the decree crooked, the establishment could simply withdraw, declare the vote null and void.
It wasn't about process then, it was about the outcome.
Exactly. It wasn't about how the decision was made, but whether the content aligned with the traditional Spartan order. It shows crystal clear that in Sparta, stability and tradition ultimately trumped whatever the immediate popular majority wanted.
Okay, so if Sparta was built on this kind of constitutional restriction, Athens was pretty much the polar opposite.
Wildly different.
It blossomed under these free democratic institutions, and our sources connect that freedom directly to their military success. There's that suggestion that if the Persians had invaded just 20 years earlier, when Athens was still under tyranny,
They might not have won at Marathon.
exactly, that maybe they couldn't have pulled it off.
And that development of the Athenian character, as the source puts it, under freedom, it really did foster the kind of civic engagement, the willingness to fight for the city that was necessary for those incredible achievements. But
Right.
that very same freedom, combined with Athens becoming a major trading hub, with capital accumulating, it created the exact instability and inequality that Plato was reacting against and trying to solve philosophically in the Republic.
Right, because as individualism and private wealth grew,
You got the sharp divide, political equality. The idea that every citizen gets one vote, one voice started to clash really brutally with the massive social and economic advantages that the wealthy citizens held.
that's the core contradiction, isn't it? The poorer citizen technically has a vote, but maybe they can't afford to take a day off work to actually go to the assembly and use it, which means the political system naturally starts to favor the wealthy, the ones who have the leisure time to participate.
Precisely. And this growing tension, this gap between political rights on paper and economic reality on the ground, that's what was driving those communistic theories that the source mentions Plato was responding to. The democracy realized it had to take some pretty radical, practical steps to try and bridge this gap, to make sure political equality wasn't just an empty promise.
And the solution wasn't, a platonic abolition of all private wealth.
No, nothing that extreme in practice.
It was paid political participation.
Exactly. To try and maintain some level of political equality across the different economic classes, the Athenian state actually started paying citizens to attend the assembly.
Really? How much?
Well, initially it was fairly modest,
Yeah.
half a drachma, but for the regular sessions, the ones that maybe weren't so exciting or were really time-consuming, they had to significantly increase the pay up to a drachma and a half.
That must have been expensive for the state.
Hugely expensive, but it was seen as a crucial practical step. Because without that payment, the assembly would have just become, in effect, an oligarchy of attendance. It would have been dominated by the people who didn't actually need to work for a living day to day. It just shows the extraordinary lengths and costs they had to go to try and keep their democratic machinery even remotely equitable.
Okay, so moving from the big constitutional challenges to the really concrete demands the state placed on its citizens. This system of democracy, built on mass participation, it obviously demanded loyalty. But crucially, it also demanded money, financial contributions.
Right. And self-interest, as the Athenians knew perfectly well, is an incredibly powerful force. It's the perennial problem for any state, isn't it?
How do you get the few people who hold most of the wealth to actually part with some of it for the common good?
Exactly. And in Athens, this really played out through these financial obligations known as liturgies.
Liturgies, like public services funded privately.
Precisely. Things like paying to equip and maintain a warship that was the triarchy, or funding a chorus for a theatrical production at the festivals. Really important civic functions, but funded by the richest citizens.
Mm.
And then there was also the aisphora,
Which was?
a direct tax, usually levied in wartime, kind of an emergency property tax.
And these weren't just like small voluntary donations we're talking about here. The sources suggest they could be a real financial strain.
Oh, they were massive burdens,
Yeah.
not voluntary at all. They were so significant, in fact, that wealthy Athenians were apparently constantly trying to, as the source says, actively seek to defend their personal interests. And it explicitly mentions they would routinely conceal their wealth.
Hiding assets to avoid taxes and liturgies. Sounds familiar.
Doesn't it just? The state was basically locked in this perpetual cat and mouse game, trying to force contributions out of the rich, who were equally determined to hide their fortunes to avoid, severe depletion. It forced the state to get quite creative legally just to try and maintain some basic fairness.
What sort of creative legal procedures did they come up with to handle all these accusations of people shirking their duties?
Well, the most famous one is the antidosis procedure.
Antidosis.
Yes.
Oh.
It was a kind of rough but very theatrical mechanism for trying to get some equity among the super rich. Here's how it worked. If a wealthy citizen felt they'd been unfairly singled out for a liturgy, say the triarchy.
Which was one of the most expensive ones.
Exactly. They could challenge another citizen, someone they claimed was actually wealthier than them and should be doing it instead. Now, the person who was challenged had only two options. Option one, they could just accept the liturgy themselves. Option two, they could agree to exchange their entire estate, their whole property, with the challenger.
Exchange everything.
Everything. And then the original challenger, now presumably much richer, would have to undertake the liturgy.
Wow. That is incredibly high stakes. It's like a legal duel fought with property deeds designed to force a really public decision about who was actually the richer man.
Exactly. It was a pretty drastic measure born out of the desperation to make sure that nobody could easily plead poverty while clearly living in luxury. But, the actual institutional change, the move towards genuine proportional liability where your burden was truly based on your actual wealth, that was incredibly slow in coming.
It took time.
Decades. It wasn't until 378 BC for the aisphora, the war tax, and even later 340 BC for the triarchy, that they really managed to enforce that principle of proportionality fully. So for a long time before that, fairness in who paid what was often pretty elusive and something argued about constantly, very publicly.
So what was the payoff then? For the wealthy citizen who did step up and take on these incredibly expensive obligations, they're pouring huge amounts of personal wealth into the city. Did they get anything back, like political influence or maybe some legal protection down the line?
Well, that was the big gamble. And it caused immense anxiety, according to our sources. They spent all this money hoping to secure charis.
Charis, that means favor, gratitude.
Favor, gratitude, prestige, maybe even a kind of stored-up goodwill. But the problem was, litigants who later found themselves in court and tried to appeal to the jury based on their past charis, their past generosity, they expressed deep worry. They were never actually sure if all those costly expenditures they'd made for the city would translate into tangible future benefits. Like, would it actually protect them from a legal attack? Would it get them a favorable ruling? There's no guarantee.
So their acts of generosity were basically a high-stakes gamble, a kind of desperate attempt to bank moral credit in a political system that was fiercely competitive, highly litigious, and often pretty unforgiving.
Absolutely. It was a system that ran on constant performance and, frankly, fear. You had to continuously demonstrate your loyalty, your generosity, your courage to avoid being publicly labeled a coward or a traitor or just a selfish shirker. And this intense public pressure, it went way beyond just financial contributions. It seeped into everything: personal honor, military accountability.
And this is where those famous political feuds get so incredibly personal, isn't it? Let's talk about that famous rivalry between the orators Aeschines and Demosthenes. Their battles in court weren't just about disagreements over foreign policy.
Oh, not at all. In Athens, the political battlefield was deliberately, institutionally inseparable from the personal feud. The system was designed to force these excruciatingly public judgments on individual character, on loyalty, on everything.
So Aeschines attacking Demosthenes.
He didn't just criticize Demosthenes' political strategies or errors. No, he went for the jugular. He attacked his basic performance of duties as a hoplite, as a soldier. He alleged failures in battle, implying effeminacy, implying cowardice.
Which, in Athens, to be publicly accused of military cowardice, that was about the worst public insult you could throw at a man, especially one trying to lead the demos, the people. It challenged his fundamental status as a worthy Athenian citizen.
It was total character assassination, aimed at stripping him of all honor. And Demosthenes' defense is just as revealing. It shows the kind of high-flown rhetoric, the appeal to the highest civic virtues that was needed to even try and counter such an attack.
He didn't just defend his actions.
No, he went on the counterattack. He appealed to the ultimate source of Athenian pride, their ancestors, their history. He swore, and this is a famous line, "By your ancestors, those who bore the brunt of the fighting at Marathon, and those who served in the phalanx at Plataea." He framed his own actions not as personal choices, but as fulfilling Athens' destiny, preserving the freedom of all Greece. It's incredibly powerful stuff.
So the courts then were much less about sorting out dry legal disputes,
Much love.
and much more like a public theater, a stage where the demos, the people themselves, sat in judgment and decided who was worthy of honor and who wasn't.
Precisely. The Athenian courts were the ultimate mechanism for the demos to hand out honor or strip it away, and to judge these intense rivalries between their leading citizens. The real lure of litigation, the source suggests, was this opportunity to submit yourself, or your rival, to a clear, excruciatingly public judgment with no qualifications, no ambiguity. This whole institutionalized process forced the most powerful men in the city to constantly, visibly, publicly defend their claims to status, to virtue, and to honor. It was exhausting, I imagine.
Okay, so this incredibly intense, you could say volatile system of public judgment in Athens, where the personal and the political were completely fused, it really stands in stark contrast to that philosophical desire we talked about earlier, the desire to find some kind of eternal, stable grounding for justice, something that wasn't just reliant on the whim of a particular jury on a particular day. Here's where it gets really interesting, I think. As the search for justice moves away from the public square, the courtroom, and more towards, well, the individual soul.
And that shift really begins with Socrates. He was searching for an internal, a rational basis for what justice actually is. According to Xenophon's account, Socrates insisted he was always showing people what are the just things, not just by, talking about it in complex arguments.
But by deed, by his actions.
By deed, exactly, by how he lived his life. And when people pressed him for a neat definition of justice, Socrates, in his typical fashion, kind of deflected. He asked, well, isn't refraining from doing unjust things, isn't that enough to be considered just?
So for Socrates, justice wasn't primarily about a complex legal code administered by the state. It was more fundamental. It was a moral action, maybe, stemming from your moral character, your inner state.
Absolutely. He heavily connected wisdom with achieving the greatest good, and specifically with self-mastery. He actually asserted that the very best for a human is self-mastery. Control yourself through reason.
So the just life is the life governed by rational self-control.
That's the idea. And that, of course, provides the direct philosophical basis for Plato's ideal state in the Republic, where the rational part, the philosopher-kings, are supposed to rule. But even among the philosophers who came after Socrates, these foundational questions remained really bitterly contested.
Like the whole question of fundamental human rights and hierarchy, which was so central to how ancient states were actually structured.
Exactly. Just take the debate over slavery, for instance. Slavery was, let's face it, a necessary institution for much of the Greek and Roman economy and society.
Right.
Now, some thinkers, particularly some of the sophists, argued that slavery was fundamentally unjust, that it rested only on convention and superior force. Basically, it was just an arbitrary rule imposed by the stronger party. Might makes right.
But not everyone agreed.
Not at all. Aristotle, a towering figure in political philosophy, he maintained that some people were actually natural slaves, that they were fit by their very nature, their lack of full rationality, perhaps, to be ruled by others. This just shows how difficult it was, even for the greatest philosophical minds, to establish a single rational basis for justice that everyone could agree on, even on something as fundamental as human liberty.
Okay, so this failure, perhaps, to consistently find the perfectly just, objective ruler in the Greek world, that leads us more towards the Roman worldview, doesn't it? Where the goal seems to shift towards codifying justice, making it permanent, trying to remove it from the ups and downs of individual human virtue.
That's a great way to put it. And Cicero's analysis of how law originated really captures this massive shift in thinking.
What did Cicero say?
Well, Cicero observed that kings, way back, were initially established specifically to promote justice. Why? Because the common people, the multitude, were being oppressed by those who had greater influence.
The powerful wealthy again. Sounds familiar.
It's a recurring theme, isn't it? The king, who's supposed to be conspicuous for his virtue, his fairness, was meant to act as this singular protector, ensuring that the high and the low were treated equally under his judgment.
So the king was almost like the Platonic ideal made real, the one just ruler who could see the whole picture and apply justice perfectly.
That was the ideal, yes. But Cicero immediately points out the crucial flaw, the practical failure. Obtaining this kind of perfect equity from one just and good man rarely occurred. Human kings, even the best ones, are fallible. They have biases, they get things wrong.
So what was the solution?
Therefore, Cicero argues, the necessity arose to invent laws, written laws that would ideally always speak to everyone with one and the same voice. The goal was to ensure the immutable, unchanging, and equitable nature of justice by embedding it in the code itself, rather than relying on the person judging. This institutionalized the idea that the written law, not the individual ruler, was the true source of stability and fairness.
And this whole move towards an eternal, codified approach really defines that core Roman legal framework, doesn't it? With concepts like ius naturale and ius gentium. These terms get thrown around a lot, often misunderstood. Let's try and clarify what they actually meant functionally within the Roman system.
Good idea. So, ius naturale, natural law, is seen as the ultimate divine and human law of nature. It's the ideal principle that forbids harming another person for your own personal advantage. It aims for unity, for security across society.
And ius gentium, often translated as the law of nations.
Right, but that translation can be a bit misleading. It was seen as a body of law established by nature, but its practical application, as described in the source, was, that is to say, by international law. However, it wasn't just about rules for diplomacy between separate countries as we think of it. It was more like the common legal ground, the basic principles applicable to all free peoples within the Roman Empire.
So internal, not external.
Primarily internal, yes. It was designed to provide a baseline of law for governing this vast multi-ethnic empire, aiming for unity and security and restraining disruption with pretty severe penalties. Things like death or exile were common punishments under it.
And I remember the source mentioning there was a historical misunderstanding about it as gentium later on.
Yes, exactly. Much later, in the early modern period, interpreters of Roman law kind of looked back and incorrectly assumed that the Roman jurists had intentionally created a system of rules specifically for international transactions between different sovereign states.
But that wasn't the Romans' primary focus.
No, the Roman jurists themselves were much more focused on establishing this common legal baseline within their own expanding empire, managing the diverse populations they ruled, aiming for internal unity and security across all these different cultural backgrounds. That was the main goal of ius gentium for them.
Okay, so they established this quite rigid, codified framework, the onerous civil, the citizen law, and this ius gentium. How did the Romans stop this eternal code from becoming too brittle, too inflexible when it actually hit the messy complexities of daily life in running an empire? Rigid laws often break when they encounter real-world exceptions.
That's a fantastic question. And the answer lies in the administrative genius of the praetor.
The praetor, the magistrate in charge of justice.
Exactly. Each year, the praetor would publish an edict. And this edict effectively created a parallel body of law known as the Aeneas
The
Honorarium.
Aeneas Honorarium. Okay.
And this Aeneas Honorarium was crucial. It, as the source puts it, stood side by side with and in effect modified the operation of the formal rules of the Aeneas Civil. The Aeneas Civil was the ancient, formal, often very rigid law that applied only to Roman citizens.
Ah, okay. So the Aeneas Honorarium acted as the system's built-in flexibility mechanism.
Yeah.
It sounds a lot like the concept of equity that developed in English common law, designed to soften the sharp edges of ancient statutes.
It functioned in a very similar way, yes. It allowed the Roman legal framework to adapt to new situations, to incorporate fairness for non-citizens perhaps, or deal with commercial practices not covered by the old laws. It let them achieve fairness in individual cases without having to go through the incredibly difficult process of formally rewriting the foundational, almost sacred codes of the Ariseus Civil. The Praetor's Edict, generating the Ariseus Honorarium, ensured that the Roman state's pursuit of justice could remain both stable and flexible. And you absolutely needed both to manage a sprawling, complex empire.
So the Roman legal system achieved this, well, unparalleled systematization of justice. It went way beyond the Athenian model in terms of structure and reach. But it was also intensely pragmatic, wasn't it? And deeply, deeply hierarchical in how it was applied. It wasn't really aiming for that theoretical equality of the Athenian demos. It seemed much more focused on precisely defining everyone's status.
That hierarchy is absolutely fundamental to understanding Roman law. You cannot separate them. The system was explicitly characterized by, and I quote, the unequal punishment of the free and unfree.
Unequal punishment.
Yes, penalties were openly and deliberately stratified based on your social standing. This wasn't just some subtle bias. It was written into the system. It was a matter of life and death, or rather, the kind of death or punishment you received.
How so?
Well, penalties that were traditionally considered servile things reserved for slaves, like crucifixion, or being condemned to the mines or thrown to wild beasts. These punishments were later explicitly applied to freeborn Roman citizens, but only if they were of low status. The humiliores, they were called.
The lower orders.
Exactly. This demonstrates a clear judicial stratification based explicitly on social rank, not just on the distinction between free and unfree. Your social class directly impacted the severity and the type of punishment you faced.
And what about the slave within this highly stratified system? How did the law actually view the most vulnerable person at the bottom of the pyramid?
Well, the legal status of the slave was primarily punitive. It's interesting, the source notes that technically, civil law and the Praetor's law didn't treat the slave as pro nullo, meaning completely as a non-person, which is a common misconception. They had some legal recognition. But in practice, a slave was primarily brought into the legal system for one of two reasons: to be punished or to witness under torture. Their legal existence was recognized mainly to the extent that it allowed the state to inflict judicial violence upon them or extract information through torture. It just confirms their utterly subordinate and exposed position within the state's hierarchy.
Okay, so as the empire kept expanding, incorporating more and more people, managing all these different statuses must have become a monumental legal headache. The law had to constantly define who was a citizen, who was a foreigner, peregrine, what rights and privileges applied to whom. The law of citizenship must have become incredibly complex.
Oh, it was bureaucratic complexity raised to an absolute art form. Our sources give these fascinating detailed examples from jurists like Gaius, outlining the precise rules around marriage and citizenship.
Like what?
Okay, get this. Imagine a Roman citizen man mistakenly marries a peregrine, a non-citizen woman, thinking she is a citizen. The law actually provided a specific legal procedure for this. If they had a son,
Yes.
the father could go to court and formally prove that it was a genuine mistake, causa erroris probatio. If he succeeded in proving his mistake, this judicial maneuver would then retroactively grant Roman citizenship to the wife, and it would place the son under the father's potestas, his absolute legal authority, as if the marriage had been valid all along.
Wow. So the law was essentially functioning as this incredibly detailed administrative tool, managing integration, managing status, allowing for controlled mobility up the ladder while still preserving the overall hierarchy.
Precisely. The law wasn't just about punishment or dispute resolution. It was a fundamental mechanism for defining and sometimes elevating identity within the Roman social structure. And, of course, managing all this insane complexity required incredibly specialized knowledge, which in turn led to the immense power and influence held by the legal experts themselves, the jurists.
Right. How did the Roman state actually formalize the power of these legal experts? They weren't just random scholars, were they?
No, not at all. The Emperor Augustus, realizing just how essential this legal expertise was for running the empire smoothly, formalized the jurist's authority. He established the aequus respondendi ex auctoritate principis, basically, the right to give answers publicly with the authorization of the emperor,
So an official state endorsement.
a direct endorsement. And the result was profound. When these officially authorized jurists reached a unanimous decision on a particular point of law, their collective opinion effectively became binding law. It had the force of statute. This institutionalization of legal expertise was an absolute cornerstone of Roman imperial governance. It provided this deep technical stability that operated somewhat independently of day-to-day political squabbles.
But this very systematic hierarchical structure, even though it allowed for technical excellence and maybe some controlled upward mobility like that marriage example, it must have also created significant social friction, particularly among the traditional Roman aristocracy, the old families who suddenly saw their inherited status being challenged by newcomers who got ahead through, say, commerce or imperial
Oh,
service.
absolutely. The friction was intense. The conservative elite, whose entire sense of worth and authority rested on birth, tradition, and land ownership, deeply resented the rise of what they saw as the wealthy, base-born parvenu, especially the freedman class, former slaves who gained freedom, and often became very successful economically.
Like the poet Juvenal, he complained about them.
Viciously. Juvenal often vented his disgust and contempt for these newcomers. They were frequently described in pretty unpleasant terms: coarse, clever, thrusting ex-slaves, and significantly, most often of foreign extraction. Their rapid economic success, their sometimes ostentatious wealth, it fundamentally threatened the traditional social and political dominance of the old Roman aristocracy. The law might have adapted to define their new legal status, but the social struggle, the snobbery, the resentment over their legitimacy, that was fierce and ongoing. Hashtag outro.
So where does this leave us? We've taken quite a journey. From Plato's ideal city, the Callipolis, which we now see was born, at least partly, out of the very real strife in Athens, through the rigid constitutional checks of Sparta, and finally landing in the incredibly systematic but also hierarchical legal pragmatism of Rome. What's the big takeaway?
Well, I think what becomes really clear, the enduring lesson maybe, is that the study of justice always starts with that theoretical construct. The philosopher-king, Plato's vision of perfect harmony, Sparta's ideal of a mixed, stable state.
But reality always intervenes.
It inevitably has to meet the messy reality of the actual political community. Human nature, driven so often by self-interest, whether it's those Athenian citizens trying to conceal their wealth to avoid liturgies, or those Roman freedmen pushing their way up the social ladder and annoying the aristocracy, that self-interest always has to be managed, controlled somehow.
And law, in all its forms, is the state's perennial attempt to do that controlling. The Spartan Crooked Decree Clause was basically a legal mechanism to stop revolution by the majority, while conversely, the Roman Praetor's Edict was a legal mechanism to prevent the system from becoming too rigid by softening the old rules.
Exactly. Different tools for different problems, but both aimed at control and stability.
So, the Athenian citizen, they fought politically in the courts, militarily on the battlefield for a state that was, at least in theory, equal, defined by public displays of honor and contribution. Whereas the Roman jurists, they were continuously adapting this massive, complex legal system, primarily to manage the practical realities of an empire full of hugely different statuses, citizenships, and economic classes.
Which really raises one final important question for us to think about.
Okay, let's hear it. A final provocative thought for you, our listeners. Given that even the most ambitious philosophical searches for some kind of eternal, absolute justice, like Plato's and the Republic, were, as our sources strongly suggest, actually rooted quite deeply in the very temporal, very specific realities of contemporary social and economic unrest. Does that mean the concept of justice is ultimately destined always to be merely a reflection of current social conventions? Just a product of its time and place, shaped by political expediency?
Right.
Or did the incredible success of Roman law in systematizing foundational concepts like that idiomus gentium, which aimed for a kind of universal applicability across cultures within the empire, did that success suggest that maybe, just maybe, a truly foundational, eternal moral law could eventually be discovered, and perhaps even universally applied, regardless of the changing whims of the populace or the particular biases of the ruling elite? Something to ponder.